Good evening. Welcome to the View Up There. I am your host, Canadian Glenn, and it is October 31st, 2018. Boo. Hope all you Halloweenies are having a good time. I'm trying to survive between coughing fits and headache just below my temple. Tonight, Bill C-75. More omnibus legislation, this time on justice, from the No-Omnibus government. Remember the 2015 campaign? Remember how Justin Trudeau said, "Omnibus legislation has no place in a democracy." There were a lot of promises made about fixing Canada's justice laws and modernizing the court. And the bills from the new government came rolling out. Bill C-28 was aimed at the punitive and inflexible Victim Surcharge regime from the Conservatives. Bill C-38 meant to proclaim into force Bill C-452 from 2015, which already had gone all the way through Parliament, addressed human trafficking. And Bill C-39 sought to remove unconstitutional and superseded sections from the Canadian Criminal Code. Now, generally, all were needed reforms with vast agreement in principle from just about everybody directly involved. But 2.5 years in, and none of them got very far in Parliament for one reason or another. Needing to demonstrate progress as the 2019 election gets closer, the government did what their predecessors did regularly by design. They tabled Bill C-75, which combined all three previous bills and had amendments on 12 existing acts, coming in at over 300 pages. Recent judgments from the Supreme Court highlighted issues not specifically addressed previously when the bills were presented. Once again, like electoral reform to reel in the Fair Elections Act, suddenly omnibus bills seemed not so bad. Well, not according to most everyone outside of government. Law societies, bar associations across the country, university law faculties across the country, civil rights organizations, even provincial governments were not impressed with Bill C-75. Despite the usual consultations and review, over 300 amendments were proposed in House committee. Government members of the committee supported a whole section of these amendments, which is a rare occurrence, and it's not over yet. Can C-75 be made palatable enough to become a law before the next election? Will it make anything better? Does it make some factors worse, as many claim? Do the Trudeau Liberals need to say they delivered on this promise when we get to next September and October? Law and order? Try political messaging instead. We're going to start at the beginning, and that would mean when Bill C-75 was tabled in the House. That was back on March 29th, 2018. Now, as I've done before on the show, what I'm going to do to get the purpose and the powers of the bill across is use something that comes from the Attorney General, a charter statement. The Minister of Justice prepares a charter statement to help inform public and parliamentary debate on a government bill. By tabling a charter statement, the Minister is sharing some of the key considerations that inform the review of a bill for consistency with the Charter. A statement identifies charter rights and freedoms that may potentially be engaged by a bill and provides a brief explanation of the nature of any engagement in light of the measures being proposed. A charter statement is intended to provide legal information to the public and Parliament on a bill's potential effects on rights and freedoms that are neither trivial nor too speculative. It is not intended to be a comprehensive overview of all conceivable charter considerations. Additional considerations relevant to the constitutionality of a bill may also arise in the course of parliamentary study and amendment of a bill. Yeah, well, we're seeing that now. But, there's one of these for every government bill. Some of them I've seen as few as 5 pages. Most, I would guess, are between 10 and maybe 20. This one is 35. And this is the first one that I'm aware of in this government where the Minister of Justice has to make a charter statement for a bill proposed by the Minister of Justice. The Minister of Justice has examined Bill C-75, an act to amend the Criminal Code, Youth Criminal Justice Act, and other acts, and to make consequential amendments to other acts, other meaning 12 there, for consistency with the Charter pursuant to her obligation. Now, they have an overview section. It does kind of very quickly explain why this bill is what it is. Bill C-75 would amend the Criminal Code, YCJA, Youth Criminal Justice Act, and other acts to reduce delays in the criminal justice system and to make it more modern and efficient. These amendments would respond to the Supreme Court of Canada decisions in Regina versus Jordan and Regina versus Cody, and also address concerns identified in the June 2017 Senate report, Delaying Justice is Denying Justice. And I'll stop for a second. The Jordan decision and the Cody decision, which reaffirmed that one, was the stink about how long it was taking for people to get to trial. There were some stays on charges, some dismissals, but, seriously, if you remember back to that, it doesn't matter what you're accused of. Why should you sit in pre-trial detention for over 3 years? What is the problem? Bill C-75 proposes broad changes, including with respect to modernization and clarification of bail, the way administration of justice offenses are addressed, preliminary inquiries, classification of a number of criminal offenses, and judicial case management. Many of the issues that Bill C-75 seeks to address have disproportionate impacts on groups that are overrepresented in Canada's criminal justice system, in particular Indigenous persons and individuals from vulnerable populations, including persons with mental illness and addictions. Bill C-75 seeks to address these issues while maintaining the safety of victims and the public. Well, of course it does. What else are you going to say? You're the government, for Christ's sake. The current bill also includes the legislative amendments contained in Bill C-28, an act to amend the Criminal Code regarding the Victim Surcharge, Bill C-38, an act to amend the Criminal Code. That's about exploitation and trafficking in persons. And Bill C-39, an act to amend the Criminal Code regarding unconstitutional provisions. Now they break down all the possible charter-protected rights and freedoms that potentially could be engaged by Bill C-75. This is no short list. So what possibly could be an issue with Bill C-75? Section 2B, freedom of expression. Section 7, the right to life, liberty, and security of the person. Section 7 and 11D, together, right to a fair trial and to make full answer in defense. Section 11B, right to a trial within a reasonable time. Section 11D, right to presumed innocent until proven guilty. Section 11E, the right not to be denied reasonable bail without just cause. Section 11F, right to trial by jury. Section 12, protection against cruel and unusual treatment or punishment. Section 15, Part 1, right to equality. Well, it's nice that you people are aware of all this. Thanks for letting us know. Now, there are some big sections to what's going on here, especially because 3 specific bills, which was the way this government said they were going to govern. Now, they've all been put together, plus more in an omnibus bill. I'm going to break this down into the big issues. The first one is bail. Now, this bill would modernize the provision for police pretrial release, including by simplifying the available forms of release, expanding and clarifying the kinds of release conditions that can be imposed, and explicitly enacting a principle of restraint for pretrial release. These amendments promote the timely release of accused persons with the least onerous conditions that are appropriate in the circumstances. In this way, the amendments promote charter values. How wonderful for you. Similarly, the bill proposes changes to the judicial pretrial release provisions, including by clarifying the latter principle that requires the imposition of the least onerous form of release, making it clear that a monetary pledge should be favored over a cash deposit for bail, and entering a specific principle of restraint for the use of surety release. These amendments would partially codify the guidance set out by the Supreme Court in Regina v. Antich in 2017, and also promote the charter values identified. Now we get into specifics, what they're targeting with this bill. Now remember, the overall goal was to modernize and increase efficiency in our justice system. What you're going to find as we go through this is there is very, very specific tinkering going on. There's not a whole lot system-wide. And some of these little tinkers actually conflict each other within the Act under a jurisprudence sense. But hey, 227 would amend subsection 515 sub 6 of the Criminal Code to establish a reverse onus on bail for persons alleged to have committed an offense involving violence against their intimate partner, if that person has previously been convicted of a same type offense. Now, reverse onus bail provision departs from the general approach to bail in two respects. It presumes that bail should be denied and that the accused should be detained pending trial, and it requires the accused to demonstrate on a balance of probabilities why he or she should be released, having regard to the three statutory grounds for pre-trial detention: flight risk, public safety, and public confidence in the administration of justice. Well, that depends who you ask, just about any day of the year. To be consistent with Section 11E of the Charter, a reverse onus needs to amount to a just cause for denying bail, meaning that denial of bail must occur only in a narrow set of circumstances, and the denial must be necessary to promote the proper functioning of the bail system and not undertaken for any purpose extraneous to the bail system. Okay, well, that is a specific flag, the Me Too movement. Is it a good idea? Yeah, it is. Does it infringe on rights in a general sense? Yeah, it does. But I'll tell you what, if there's a reverse onus on anyone who refuses to give a breathalyzer sample, then I think there should be a reverse onus on someone charged with partner violence who's already been convicted of it. I don't see that as a stretch. Sorry. Clause 228 would establish new procedural requirements before a particular person can be named as a surety. A surety is an individual designated by the court to supervise an accused person who has been granted bail and to ensure that the accused fulfills the pledge to appear for trial. Clause 228 would require a potential surety to provide a signed declaration to the court, setting out some listed facts about themselves, along with several acknowledgments relating to the responsibilities assumed. This is intended to be an efficient way to standardize the basic information provided to courts for the purpose of assessing the suitability of proposed sureties. I think the gist behind this was judges all have a different standard for qualification as a surety. I believe what the feds are looking for here is to establish some sort of checklist. No more screwing around because, you're a hard-ass judge as compared to this guy. I can understand that. However, Clause 228 would have potential impacts on the accused. If a particular surety cannot fulfill these requirements, then that could impede the ability of the accused to secure pretrial release, and a court could be required to find other means of constituting reasonable bail. The presiding judge has discretion to exempt a potential surety from the declaration requirement, where appropriate. Alrighty, there we go. Fixed. The bill would amend the provisions for mandatory judicial reviews of pretrial detention orders so that these reviews must occur every 90 days for all accused persons. This would not change the frequency of mandatory review for those charged with indictable offenses, but it would decrease the frequency for those charged with an offense prosecutable on summary conviction. Again, this is screaming about efficiency, but it's doing nothing to promote the charter. It's doing nothing to promote the process that is supposed to be getting people moved through the system. All it says is that, well, all these people who are pretrial detained on summary conviction, which is a whole nother ridiculous issue, yeah, we're just going to review their shit once every 3 months instead of every month. So what does that tell you about their idea of how quick they're going to get these people moved out? Now, of course, the judge can direct that proceedings be expedited and require that the next mandatory judicial hearing occur sooner than the default 90-day period. If the accused person wishes to have their detention reviewed before the next mandatory hearing, he or she has a right under Section 520 of the Criminal Code to apply, quote-unquote, at any time for a review of the detention order. Okay, of course, no word about if that actually happens or gets lost in the mail, never mind. The administration of justice offenses. This is breach of conditions. This is a huge problem in courts all across Canada. Clauses 214 and 236 would create an alternative mechanism for responding to certain administration of justice offenses, such as failure to appear, non-compliance with bail conditions. Now, it would provide an alternate mechanism where the failure in question has caused no harm. Typically, under the current law, cases involving a breach of a condition or a failure to appear will result in a new charge being laid or bail being revoked. C-75 would create a regime that enables the police to decline to charge the individual, but require them to attend court for a judicial referral hearing. At this hearing, the justice would have a number of options, including no action, varying the terms and conditions of release, or revoking bail. Once a decision is made, no further charges may be laid for the failure that was the subject of the hearing. But again, you're increasing the efficiency of the court system by having more hearings. I think the important part here is the cops have the option not to charge for a breach. Will that happen? You tell me. Compared to the current alternatives of charging or revoking bail, the breach referral hearing would facilitate a less intrusive and more tailored response by the criminal justice system to certain administration of justice offenses. Intimate partner violence. Clause 297 would create a new provision in the sentencing of the Criminal Code that would allow the Crown to seek to have a higher maximum penalty where an offender is being convicted on indictment of a second or subsequent offense involving violence against an intimate partner. Okay, that sounds reasonable, right? Clause 296 would amend the sentencing provisions in Criminal Code Section 718, specify that evidence that an offender abused their intimate partner in committing an offense is an aggregating factor for sentencing purposes. It will also clarify that both current and former spouses or common law partners and dating partners are included in the definition of intimate partner for these purposes. Clause 297 sounds very noble, but how many of those cases actually exist? Offender is being convicted on indictment of a second or subsequent offense. Yes, absolutely. Under those circumstances, I think this is a correct diagnosis. But convicted on indictment, there are people out there who have been convicted on multiple charges on summary conviction. The argument can be made that they are serial abusers, but they've never been indicted. It's been summary conviction. So it looks good. It's another flag to the Me Too universe. But what's it really fix? Preliminary inquiries. Now, that is a hearing to determine whether there is enough evidence to require an accused to stand trial for an alleged offense. Now, currently, a preliminary inquiry will take place if A, an accused person is charged with an indictable offense, for the most part, there's a few excluded, and elects to be tried before a superior court, or B, is charged with an offense listed in Section 469 of the Criminal Code and requests that one be held. Now, this bill would restrict the availability of preliminary inquiries for adults accused to offenses liable to life imprisonment. And for example, that would be homicide, commission of an indictable offense for a criminal organization or terrorist group, kidnapping, arson. You can still get a prelim for them. The amendments also would provide that the preliminary inquiry justice may limit the scope of the inquiry to specific issues and limit the witnesses to be heard on these issues. The statutory in the paragraph 540, sub 1, sub A of the Criminal Code, accused or counsel for the accused to cross-examine the prosecution's witness at a preliminary inquiry would remain. This recognizes that the justice has the power to regulate the inquiry and to ensure that inquiries are conducted in an efficient manner. The justice would be required to exercise this power in a manner to promote a fair and expeditious inquiry. In so doing, the justice would take account of the rights of the accused to both a fair procedure and a trial within a reasonable time. Well, sounds good. Doesn't say how it's going to happen, but it sounds good. The reclassification of offenses. This has been a big issue in committee. This was the area where Liberal members of the committee actually voted with the Conservatives to amend. The bill would hybridize, with some exceptions, all indictable offenses in the Criminal Code, which are currently punishable by a maximum penalty of 10 years or less. The result of hybridization is that those offenses could now be prosecuted either as an indictable offense or as a summary conviction. This requires amendments to offenses throughout the Criminal Code. C-75 would also increase the default maximum penalty to 2 years less a day for all summary conviction offenses. The maximum fine that could be imposed for summary conviction offenses would remain $5,000. This is a huge issue. There are people on both sides of the fence on what the purpose of this is from the government's point of view. Is it to provide flexibility and shorter timelines for prosecutions to go forward, or is it an invitation to make a deal and get a conviction? There's a general norm that people who are in charge with indictable offenses understand that this is a superior court case, either with jury or by judge, and it's serious business. So people are more serious about getting defense, tabling a good defense, and beating it because it's a big deal. Summary convictions, that seems to fall off. So they have the opportunity to move a 10-year indictable offense down into summary conviction. Well, what about the people at the bottom, with a maximum of, say, 3 months or something? Now, everything like that, the maximum will now be 2 years less a day, the longest bit you can serve in a provincial jail. And this is going to speed up the system. How? Some of the offenses that would be hybridized, or whose summary conviction penalty would be standardized, carry mandatory minimum penalties ranging from mandatory fines to mandatory terms of imprisonment. Now, for example, Section 255 of the Criminal Code provides mandatory minimum fines and mandatory terms of imprisonment for the offenses of impaired driving and failure to comply with a valid demand. The minimum penalties range from a fine of $1,000 first offense to imprisonment for not less than 30 days for a second offense to 120 days imprisonment for each subsequent offense. So with C-75, that would be amended. The maximum penalty on summary conviction is no longer 18 months. Now it's 2 years less a day. Now this is also included in the brand new C-46, which deals with conveyances and legal demands, and tried to use a word of the moment, hybridize marijuana into it. At that point in time, it was currently before the Senate, but it's through now. As part of this reclassification, The bill would amend the offense of publishing a defamatory libel, knowing it to be false, so that a person would be liable on summary conviction to a term of imprisonment of 2 years less a day. The offense of publishing defamatory libel, knowing it to be false, prohibits unjustifiable attacks on a person's reputation. Did you hear that, Ezra? You could go for 2 years next time. Coordinating amendments with Bill C-46. These include the mandatory minimum fines for first offenses of driving with a high blood alcohol concentration, $1,500 fine for a driver with a BAC of 120 milligrams per 100 milliliters, so that's a 1-2, and a $2,000 fine for 1-6, or refusal to comply. Those are the new minimums. The higher fines for drivers with high blood alcohol contents proposed in Bill C-46 create stronger penalties where an individual has chosen to drive in a state where they are highly intoxicated. See how they justify moving summary convictions up the ladder. They talk about guys who get convicted of being severely hammered on the road. They don't talk about all the other things that no longer have a 3-month maximum or a 6-month maximum. Now it's 2 years. Another big deal is the admission of routine police evidence and transcripts of police evidence. Clause 278 of C-75 would allow for the introduction of certain evidence by police officers in written form. This is a departure from the typical approach to evidence in criminal proceedings, especially trials, which involve evidence introduced through oral testimony and an opportunity for cross-examination. Clause 265 would allow routine police evidence, if otherwise admissible through testimony, to be admitted into evidence in criminal proceedings via affidavit or solemn declaration. The presiding judge would have discretion whether to allow admission of this evidence in written form. The judge would also have discretion to require the attendance of the officer in court for an examination in chief and or a cross-examination. This could be done on the judge's own motion or at the request of a party. If they have 3 outs attached to this, why are they even doing it? So they can say, look, we changed the law. We're speeding things up. Except everybody makes a motion and it never happens. Similarly, Clause 294 would establish that transcripts of police evidence are admissible in criminal trials where that evidence had been given in the presence of the accused at a voir dire or preliminary inquiry on the same charge. The presiding judge would have discretion to require the attendance of the officer in court to testify or be cross-examined. There are a lot of people in the criminal defense community that are not impressed with this. It brings up the question of weak defense, status for legal aid, the condition of said legal aid, which has been decimated for quite a long time. It's very ambiguous. I think a lot of these things, there is no predictability on whether this will hurt or help. And it doesn't do anything to tackle the base issues, such as being so many vacancies on benches appointed by Ottawa, which would be Superior Court or Queen's Bench in every province, Appeals Court in every province, and the federal courts. Remote appearances. C-75 would amend the criminal code to modernize and facilitate the appearance by audio conference or video conference of all individuals involved in criminal cases, including a judge or justice, throughout the process. The court would be empowered to allow the use of such technology to facilitate the remote appearances at any stage of the process under certain circumstances. The purpose of these amendments is to serve the proper administration of justice, including by ensuring fair and efficient proceedings while respecting the accused's rights to a fair trial and to make full answer in defense. The use of these tools would be discretionary, thus permitting the court to balance the relevant considerations. Again, discretionary. What are you really changing in these 300 pages? Youth Criminal Justice Act amendments. Now, C-75 would make various YCJA amendments to encourage a more flexible response to administration of justice offenses, both at the bail stage and where a young person breaches the conditions of community-based sentence. The amendments would encourage increased reliance on extrajudicial measures where appropriate. It sounds good, but again, it takes the people in the system to employ these changes. If they don't want to do it, nothing changes. It doesn't matter what the law says. Clauses 364 to 377 would modernize the Youth Criminal Justice Act provisions for police and judicial pretrial release. In addition, these amendments would codify a principle of restraint for conditions imposed on judicial release and explicitly prohibit the imposition of pretrial release conditions and the use of detention as a substitute for appropriate social measures. These amendments promote the timely release of young persons with the least onerous conditions that are appropriate in the circumstances. Similarly, the bill would enact a principle of restraint in relation to conditions imposed at sentencing. This would promote charter values because it would seek to further minimize the restrictions on liberty that result from a sentence under the Youth Criminal Justice Act. Something that we're going to get to as we go through the review from people who are not the government. The other backdoor advantage to omnibus legislation is there is so many things in here. It takes a while for them to be examined and broken down and cross-coordinated with the other acts it affects, and to come up with a coherent response. Will you get into committee? Did you miss committee? Omnibus legislation is insidious. Yet one of the other big things is the reforms to the jury selection process. C-75 would amend the criminal code to abolish peremptory challenges, empower the judge to decide all challenges for cause, and enact other measures to strengthen the jury selection regime. Currently, both the prosecutor and the accused are entitled to the same number of peremptory challenges, the exact number varying depending on the nature of the offense. A peremptory challenge allows either the prosecutor or the accused to exclude a potential juror without giving a reason. This has led to concerns that these challenges can be used in a discriminatory fashion by the prosecutor and the accused. In addition, the prosecutor and the accused have an unlimited number of challenges for cause based on grounds set out in the criminal code. These challenges will remain in the criminal code after Bill C-75 is brought into force. The elimination of peremptory challenges is what's happening here. You're allowed to challenge as many as you want, but you have to explain yourself. No more peremptory challenges. Of course, where this came from was in the Gerald Stanley trial for the death of Colton Boushey. The issue was raised again of a all-white jury trying a white defendant in the death of an Indigenous man. The government has addressed it. Will this work? We don't know. We'll see. There are most other countries that use a system like ours, a system of government, a system of justice like ours, have eliminated peremptory challenges anywhere from 10 to 30 years ago. A lot of countries have in the Commonwealth. The bill would modernize the language found in paragraph 638, sub 1, sub D of the Criminal Code, which permits a prosecutor or an accused to challenge a juror for cause on the ground that the juror is an quote-unquote alien. This language would be modernized to provide that a juror who is not a Canadian citizen may be challenged for cause. The exclusion of permanent residents from serving as jurors may engage their equality rights as protected under Section 15.1. Nice to draw attention to that, but they do explain themselves. As in all democratic societies, citizenship is a status to which certain rights, privileges, and obligations are attached. Service on juries has historically been viewed as one of the duties that are corollaries to the rights associated with citizenship. Jurors are required to be citizens because, as triers of fact in a criminal trial, they are directly participating in an adjudicative decision and are involved in the process or structure of government broadly defined. The requirement for jurors to be Canadian citizens facilitates jurors' important function in the criminal justice process and enhances the accused and public's confidence in the jury. Being the asshole advocate that I am, that all sounds well and fine. You should be a Canadian citizen to be on a jury. But considering what brought the elimination of peremptory challenge to being a priority, how long before we see a case in a federal court about whether certain Indigenous First Nations are citizens of Canada? And what will be the spillover? Just saying. This bill also includes the legislative amendments contained in Bill C-28, C-38, and C-39. Now we look at C-28. The victim surcharge is an additional monetary penalty of a fixed amount, which is automatically imposed on adult offenders at the time of sentencing. Where an offender is sentenced for multiple offenses under the Criminal Code and or the Controlled Drugs and Substances Act at the same time, a victim surcharge is imposed for each offense on a cumulative basis. Now, Section 12 of the Charter prohibits grossly disproportionate punishments. In certain circumstances, the current surcharge provisions may require judges to impose significant surcharge amounts. For example, when multiple surcharges are cumulatively imposed on offenders in relation to administration of justice offenses that do not cause harm to a victim. This has the potential to be found to constitute grossly disproportionate punishment. Gee, funny you should say that. That's exactly what everybody said when Harper made it law. Now, for a Cliff Notes version of that, somebody selling drugs at the street level, say they have 4 baggies on them. That could be 4 victim of crime surcharges. He didn't sell them. They're in his pocket. Who did he hurt? Clause 304 in Bill C-28, discretion for judges in certain circumstances. Judges would have the discretion to exempt an offender from payment of the surcharge if the offender establishes that payment would cause undue hardship. This would promote core values that underpin the Charter, including liberty, equality, and the right not to be subjected to cruel or unusual punishment. Makes sense to me. Subsection 737 provides judges with the discretion to impose fewer surcharges than the number of offenses. Undue hardship in these circumstances is defined in subsection 737 sub 6. It means the offender is unable to pay because of unemployment, homelessness, lack of access, assets, or other financial obligations towards their dependents. Now there we go. It revokes all these stupid mandatories, judges can't do anything, that the conservatives put in. So that makes total sense. They promised that, but it's still not law yet, so now it's in this package. Bill C-38 was about Bill C-452, an act to amend the criminal code regarding exploitation and trafficking in persons. It received royal assent in June 2015, but has yet to be proclaimed into force. It would amend the criminal code by enacting section in the criminal code 279.05. This provision would require the imposition of consecutive sentences for human trafficking offenses and other related offenses arising out of the same event, many of which are punishable by mandatory minimums. So that's a hammer. Anybody caught, if this goes through, will get that big, tough trafficking law that conservatives sold but never made law. This bill that they're looking to bring back, Bill C-452, would amend the criminal code by enacting subsection 279.01 sub 3, which allows prosecutors to prove one of the elements of human trafficking, namely the accused exercise control, direction, or influence over the movements of a victim. It would change that could be established by proving the accused lived with or was habitually in the company of the victim. Before this, prosecutors needed to prove all of those elements beyond a reasonable doubt through direct or circumstantial evidence. In this case, although the accused would be given the opportunity to raise a reasonable doubt, the prosecutor would only need to prove that the accused lived with or was habitually in the company of the victim to make one of the elements apply for trafficking: control, direction, or influence. It does mention that the Charter may find a problem with this, but the Supreme Court of Canada upheld a similar evidentiary presumption in the context of prostitution-related offenses. That decision gives justification for this clause, according to the Minister of Justice. Bill C-39 was to get rid of the garbage in the criminal code. That bill would repeal or amend several criminal code provisions that the Supreme Court of Canada has previously found to be of no force or effect because of inconsistency with the Charter. Section 179, loitering, found unconstitutional in 1994. Spreading false news, too bad, found unconstitutional in 1992. That was the Ernst Zundel case. Unlawful object murder, part of which was found unconstitutional in 1990. Murder in the commission of offenses, found unconstitutional in 1990. Impaired driving, the presumption of accuracy of breath or blood samples, parts of which were found unconstitutional in 2012. Abortion is still on the books, which was found unconstitutional in 1988. The credit for pre-sentence custody in sentencing, another Harper gem, was found unconstitutional in 2016. Now, of course, they say these proposed changes would promote the rule of law. Well, gee, that's a good idea. The bill also includes amendments to repeal the prohibition on anal intercourse. Anal intercourse is the modern term for buggery. It was originally prohibited by the buggery offense. Other types of sexual activity that were historically considered to be immoral or unnatural, but did not involve intercourse, were prohibited by the gross indecency offense. In 1969, the criminal code was amended to decriminalize buggery and gross indecency between married persons of the opposite sex and between adults who were at least 21 years old, provided that the conduct was consensual and took place in private. That would be one of the things that Pierre Trudeau became famous for. These laws were in the first criminal code in 1892. They will finally be removed. There is some changes as well to the general sexual assault and child sexual assault charges. The repealed offense provisions would continue to be available to prosecute conduct that is alleged to have occurred prior to 1983. So they're removing old stuff that has been superseded, but if the crime took place when this law was the only one on the books, it will still apply. So I have to say I think that is good, but that's what the government says. That's what it affects the charter on. 35 pages worth. And that was at the end of March. So it took about 3 days before comments started flowing forth. I'm going to go to one piece that appeared in the Globe and Mail that was in favor. Just, yeah, this is a great bill. Everything else I have doesn't share that opinion. But on April 6th in the Globe and Mail, Alan Rock, familiar name? Alan Rock wrote an editorial in the Globe and Mail that said, Bill C-75 is justice reform that makes sense. And for younger listeners, they're saying, who the hell is Alan Rock? Alan Rock is President Emeritus and a Professor of Law at the University of Ottawa. And, oh, by the way, he's a former Minister of Justice and Attorney General of Canada, Chrétien government. In the summer of 2016, the Supreme Court delivered an unequivocal call to action. It called on all criminal justice system actors to undertake real transformative change. It called for an end to the culture of complacency plaguing our courts. The Jordan decision, one of the few Canadian court decisions to become a household name, created the expectation among Canadians that their government would act to improve the criminal justice system. Bill C-75 is the Trudeau government's response to that challenge. While the proposed legislation does not address all of the problems in the system, it would resolve many of them. It is a commendable piece of legislation and it merits the support of Canadians. Much of the bill is in direct response to the Supreme Court decision. The court explicitly encouraged Parliament to consider the value of preliminary inquiry in light of expanded disclosure obligation, a call echoed by provincial attorneys general across the country and by some chief justices. When they were created, prelims provided the principal means by which the accused learned the particulars about the Crown's case against them. Nowadays, stringent obligations compel prosecutors to make full disclosure as a matter of course. In short, preliminaries are no longer necessary. Remember, it's a former Minister of Justice that is just dismissing it just like that. While preliminaries occur in only 3% of cases, they have a disproportionate impact. In the Jordan case itself, the preliminary took a full year to complete, including 9 days of court time. Cases that include a prelim take an average of 4 times longer to complete than those that do not. The Supreme Court has already held that preliminaries are not necessary in order for the accused to have a fair trial, nor is there a constitutional right to a preliminary hearing. Bill C-75 would bring about an 87% reduction in the number of preliminaries. That would provide welcome relief for an overburdened system. The proposed bail reforms, along with changes in the way administration of justice offenses are handled, will unclog the courts while also addressing the overrepresentation of vulnerable communities in pretrial custody. In many detention facilities, there are more people awaiting trial than those who have been convicted, and evidence shows that Indigenous people and members of vulnerable populations are more likely to be denied bail. Bill C-75 will improve the bail system in several ways. It will direct the police and judiciary to follow a principle of restraint instead of imposing burdensome conditions that set the accused up for failure without improving public safety. It will also require the court to consider the circumstances of accused from vulnerable, marginalized, and Indigenous populations, and to ensure that any conditions imposed are necessary for public safety and the administration of justice. Well, Mr. Rock, that all sounds very noble, but I mean, let's get serious. We know how it works, especially in provincial court. Prosecutors know who their judges are. Judges know who their prosecutors are. They're going to get done what they want to get done. Doesn't matter what your laws allow. At present, the only option for police, other than ignoring the breach, oh my God, imagine that, is to lay a fresh criminal charge against those who violate bail conditions. The consequences are significant. 40% of cases before the courts involve at least one so-called breach. Bill C-75 will empower the court in those cases to issue a warning, vary the bail conditions, or revoke bail. He sums up by saying judges will be given new case management tools. There will be increased use of technology in the courtroom, and peremptory challenges of prospective jurors will be eliminated. The Supreme Court called on the government in the Jordan case to ensure that the criminal justice system is conducive to timely justice. Bill C-75 responds to that call. While it is disappointing that the legislation does not roll back the many mandatory minimum penalties irresponsibly imposed by the Harper government, Bill C-75 will result in a significant improvement to the fairness and effectiveness of the Canadian criminal justice system. Well, at least Mr. Rock had the balls to mention that mandatory minimums, which are still working their way towards the Supreme Court as being unconstitutional, are not being changed at this point in time. As I said, that was the only editorial, guest column, whatever you wish to call it, that was just, yeah, this is a great bill. This is awesome. The only one. And that was in the first week of April. Here we are in just about November. And there's been nothing else like that since. April 2nd, Stephanie DiGiuseppe in the Toronto Star. Liberal bill a step backward for Canadian justice reform. On Thursday, the federal government released Bill C-75, an omnibus bill aimed at reducing court delays. Unfortunately, good intentions stop at the preamble, especially for those of us who believed in the government's pre-election promise to bring a principled approach to criminal justice reform. Speeding up the system has been on the agenda since the Supreme Court's Jordan decision, which strengthened the law surrounding breaches of the right to trial within a reasonable time. However, in Ms. DiGiuseppe's opinion, C-75 uses Jordan as a pretext to erode charter rights and procedural safeguards. Bill C-75 purports to speed up the system by eliminating preliminary inquiries for all but the most serious offenses. On a superficial level, one might expect that removing a step in the pretrial process would unencumber judges enough for matters to proceed to trial more quickly. However, C-75 reclassifies a myriad of offenses, giving the Crown discretion to prosecute them summarily. To further incentivize this option, the bill increases the maximum penalty for summary offenses from 6 months to 2 years. Summary offense trials, like preliminary inquiries, occur in provincial courts, which are already the most congested courts in our system. C-75 may very well take many preliminary inquiries off the provincial court docket, but it will replace them with many more trials for summary conviction. Promptness is not the only meaningful metric for assessing justice reform. Preliminary inquiries are discretionary, and since they slow down the process, an accused will generally only opt for one where it will enable counsel to obtain essential disclosure, narrow the issues, or arrive at a fair resolution. Narrowing issues means shorter trials. Resolution results in fewer trials, and disclosure creates fairer trials. C-75 would also repeal peremptory challenges, which recently upset the Stanley trial, where the defense notoriously used challenges to eliminate Indigenous jurors. However, most often, peremptory challenges are not used this way. They are used to achieve fair and representative juries. During the peremptory challenge process, each potential juror is brought forward and asked to look upon the accused. You can learn a lot from that look. Some potential jurors appear with defiance, contempt, or fear on their faces. Others show compassion, interest, or equanimity. As a defense lawyer, Ms. DiGiuseppe prefers the latter on her juries. The federal government could have responded to the Bushi debate by providing counsel more freedom to vet jurors, or by creating a mechanism to challenge discriminatory use of the veto. Instead, it proposes to repeal one of the few tools counsel have to eliminate jurors who may not believe in the presumption of innocence. The most troubling aspect of C-75 is that it will allow the Crown to introduce written evidence from police officers about routine matters and force the defense to apply for permission to cross-examine them. The definition of routine matters is so broad, it could cover the entire spectrum of police evidence. Applications to cross will be numerous and time-consuming and will undoubtedly clog up the system. As society becomes increasingly aware of intolerable police practices, such as carding and induced confessions, the federal government is tabling legislation that seems to protect such behavior by eliminating the discovery-focused cross-examination that occurs at preliminary inquiries and by making it much more difficult to cross-examine police officers at trial. Cross-examination has been called the greatest legal engine ever invented for the discovery of truth. Limits on a cross interfere with the trial's essential function, the search for truth. Cross-examination also provides a check and balance on police abuse and corruption. My prediction, if this would be Ms. DiGiuseppe's prediction, if Bill C-75 passes into law, the Canadian justice system will be slower, less fair, and will encourage police abuse and an increase in wrongful convictions. Well, that's certainly not echoing former Minister Rock's sentiments. From the CanadianLawyerMag.com on April 9th, Michael Spratt. Late last month, in the dying hours before a long weekend, Minister of Justice Jody Wilson-Raybould, flanked by her parliamentary secretaries Marco Mendicino and Bill Blair, unveiled her self-described and long-promised bold criminal justice reform. The legislation, Bill C-75, was billed as a silver bullet to unclog our courts and bring about a cultural shift in the justice system. The changes may be bold, but in this case, the proposed reforms will likely result in more delays and more unfair trials. Wilson-Raybould's bold legislation was met with an immediate, loud, and visceral condemnation by criminal defense lawyers, calling the bill an utter and complete betrayal, an erosion of procedural safeguards that gravely misses the mark, a regressive blindside, and, get this, worse than anything Harper ever did. There is no question that we need swifter justice in our court. Dockets are overflowing, and it can take years for a criminal allegation to reach trial. This is not because accused people want to delay cases. Clients, especially those in custody, beg for earlier trial dates. Every actor in the justice system wants to speed up the process, but we can't. You see, our courts are clogged with petty offenses that all too often are the result of addiction, mental health, and poverty. These offenses should be diverted from the criminal system, leaving our courts better ready to tackle serious and violent crimes. The criminal code is also still overflowing with all of the Harper-era minimum sentences, which are an unfair and oppressive drain on court resources. These are the obviously bold reforms the justice system is in desperate need of. It seems that Wilson-Raybould was on board. Not only were these reforms an election promise, but in a 2016 speech to the Criminal Lawyers Association, Wilson-Raybould was crystal clear in saying that restoring judicial discretion was an issue of utmost importance. She told the crowd that justice could not be a one-size-fits-all proposition. Specifically, she said that mandatory minimum sentences were a priority for change and promised reforms were coming. Wilson-Raybould also promised transformational and charter-compliant justice reform and highlighted the all-too-obvious problem of the disproportionate criminalization and incarceration of minorities and marginalized groups. But after the introduction of Bill C-75, it is clear that Wilson-Raybould has chosen to ignore her promises and at the same time turn her back on the root cause of delay. Instead, she seems content grabbing the lowest hanging, most dangerous, and most counterproductive fruit. Bill C-75 promises to speed up court cases by eliminating preliminary hearings for all but the most serious. Also quietly slipped into the bill is a provision that would allow Crown prosecutors to simply file written copies of police officers' evidence. Not only will these changes waste more court time than they save, they will erode fundamental safeguards of trial fairness. Preliminary hearings account for only about 3% of all court time. In that context, Wilson-Raybould's claim that her legislation will reduce their use by 87% sounds a bit less inspiring. What Wilson-Raybould conveniently leaves out is that preliminary hearings not only increase fairness, but actually save court time by weeding out weak cases, focusing trials, and increasing the likelihood of guilty pleas. Under the new rules, more cases will go directly to trial, and those trials will be longer and less focused. I would like to add that I expect a blow-up in the number of voir dires that will be happening in serious criminal trials now, because there's no preliminary hearing. Wilson-Raybould has inexplicably chosen to prefer policy-based evidence-making over evidence-based policy-making. In his 2007 report on the wrongful conviction of James Driscoll, who spent 13 years behind bars for a crime he did not commit, Justice Patrick Lesage noted that preliminary hearings are an important safeguard for fair trials. Ultimately, his commission of inquiry found that the prelim inquiry has a long history in Canadian criminal law and is often of immeasurable assistance to the Crown, and more often to the accused in reducing the likelihood of miscarriages of justice. But fairness seems to be taking a back seat on Wilson-Raybould's priority list. The out-of-the-blue change to shield police officers from cross-examination is particularly cynical and counterproductive. If an accused wants to actually ask a police officer any questions at trial, they will be forced to disclose their trial strategy and ask the judge for permission. Here's a prediction from Mr. Spratt. These applications will always be granted, but of course all those applications to ask questions of police will eat up court time and cause more delays. Wilson-Raybould has betrayed her promise that reforms to Harper's punitive, time-consuming, and counterproductive minimum sentence laws were coming soon. The Harper government passed law after law that removed judicial discretion from sentencing and embraced harsher and more vindictive punishments. But at least the conservative measures did not imperil due process, and that is exactly what Wilson-Raybould has done. Something worse than what Taves, Rob Nicholson, Peter MacKay, or Stephen Harper ever did. Wow, that is a harsh last sentence. And Michael Spratt, of course, is highly respected. Now, a little bit more about this thing about police don't have to show up. They can just, have it written down. Yeah, here you go. Imagine what this would do to traffic court. Megan Campbell in Maclean's. Still, early April, everybody's still getting a look at this thing, flipping out. Tim Quigley is a law professor emeritus at the University of Saskatchewan. I quote Mr. Quigley, "I absolutely abhor omnibus bills because often tucked away in there are things that nobody really sees, or in the case of Parliament, nobody gets to ask questions on. Section 657 of the Criminal Code would change under Bill C-75 to give courts the discretion to accept police evidence in writing instead of requiring officers to testify in person. It could mean defense lawyers, in some cases, cannot question police on the stand." A week and a half after the legislation was tabled, the Criminal Lawyers Association released a position paper on the bill, including the proposed change to Section 657. While police officers say the provision would save them wasted days waiting around in courtrooms, defense lawyers argue it would prevent them from scrutinizing police investigations, and the provision could pass with little debate in Parliament. Lisa Jorgensen is a board member of the Criminal Lawyers Association. It was definitely hidden away. We can't possibly fathom why anyone would think this would be a good idea. It's concerning that it wasn't put forward, front and center for proper debate. In her opinion, along with the abolishment of preliminary inquiries, it's one of the two biggest changes in the entire bill. Megan Campbell goes on to explain this position a little better. The amendment to Section 657 states, in any proceedings, the court may allow routine police evidence, if otherwise admissible through testimony, to be received either as affidavit or solemn declaration of a police officer, and may, on its own motion or at the request of any party, require the attendance of that police officer for the purposes of testimony or cross-examination. When police officers tell inconsistent stories on different days of testifying, the inconsistency can strengthen the defense's case. If we don't have an automatic ability to test the evidence, there are real concerns that judges may, in the interest of time efficiency, not exercise their discretion to permit cross-examination. That is how we test evidence in Canada. Scott Reed, a defense lawyer from Toronto, says that the provision broadly defines routine police evidence as evidence including observations, analysis, arrests, and other routine activities. Mr. Reed says that effectively covers everything a police officer could do. He compares Bill C-75 to past work by the previous Conservative government. I am hard-pressed to recollect any piece of criminal law legislation as regressive as this one. They all pale in comparison to this piece of legislation and how bad it is. Now, the whole premise of allowing police to submit in writing to free them up for all this other stuff. Now, police officer unions, of course, welcome the changes, as they sometimes spend days in court, only to be excused without the need to testify. However, if police officers submit written testimony, they will still need to spend time working with counsel to write their submissions. The Criminal Lawyers Association say they were not consulted in any way, shape, or form for what C-75 turned out to be. Now, don't you think it would make more sense if a lot of this stuff was reported and communicated in a more layman framework? You know, I mean, the law can be very convoluting and confusing. I mean, most of the serious papers you're going to find opining on C-75 is going to be in the law industry press, university law faculty papers, that sort of thing, which makes perfect sense. But there's not really all that much explaining out how this will work to Joe Schmo. Well, in June, there was a lengthy article published anonymously at North Shore Counterinfo. So I can't quote an author, but A Criminal's Guide to Bill C-75, Understanding the Liberal Crime Bill. Now, this critique of Bill C-75 is definitely more my style. It's the Colton-Boushey bill and the Me Too bill. It's the bill that wants to speed trials up and change how people are impacted by bail while waiting. It's a bill that frees the state's hand to treat minor crimes more seriously or to use serious crimes more lightly. It's a bill that talks about having fewer youth in the system but makes it easier to charge them as adults. It's the bill that lets cops avoid cross-examination, sends you to court by video, and formally decriminalizes anal sex. It's a 300-page omnibus bill from the party that spent years promising to never use omnibus bills. Bill C-75 is currently in committee federally, and it aims to make major changes to the justice system across Canada. For a bill of such sweeping scope, though, it hasn't been much discussed outside of political and legal spheres. However, the legal system and the cops and prisons that come with it are the backdrop of so many choices we make every day, structuring what we think possible in both big ways and small. It affects all of us. There are 3 areas that will be addressed here. This is what determined the direction of C-75 from the anonymous author. It is to respond to Supreme Court rulings that restrict how long cases can take to get to trial and that seek to reform the bail system to reduce pretrial detention and the use of harsh bail conditions. Now, these rulings made by the Supreme Court are considered progressive by those who follow such things, but how specifically the House of Commons is taking them up raises big questions. It is a response to social movements, notably those around the trial for Colton-Boushey's homicide and those calling for an end to sexual violence. It will give the prosecution more flexibility in determining the seriousness of crime, which gives them more power to secure deals, makes certain laws easier to apply, and allows them to punish minor crimes more severely. Now, he goes a little bit into detail about responding to the Supreme Court rulings known as Jordan and Antich. The House has a responsibility to ensure that the criminal code and related legislation fit with rulings by Canada's courts. However, the political nature of their response is important, since the Liberals try to present themselves as at once humane reformers and also close to the mainstream consensus on crime. The Jordan ruling deals with how long it takes for trials to happen. The Supreme Court ruled inadequate the existing provision for deciding when delays in getting to trial had violated a defendant's rights. The judges imposed a solid deadline where none existed before: 18 months for cases being tried in provincial court and 30 months if it went to a superior court with a preliminary inquiry. Now, see that? There's another reason they want to cut preliminary inquiries. This led to a bunch of cases being thrown out across the country because of delays. Typically, it's in the Crown's favor to drag things out as much as possible because of how many people wait for trial in prison and because of the restrictive bails that are the default in most of Canada. The process is the punishment. More time waiting for trial means more people plead guilty. Addressing the challenge of Jordan appears to be the main goal of C-75, and as much as the bill tries to eliminate steps and speed things up to meet the deadlines, those opposed to preliminary inquiry say that since 1991, the Crown has been required to disclose their case before trial anyway. Those in favor of prelims say it allows courts to focus on the issues and leads to speedier trials. So is it brilliant time savings or false economy? Depends who you ask. Now, just for example, the person accused in the Junex anti-fracking occupation in Quebec were dropped following a preliminary inquiry because the inflated political charges against them didn't hold up. This saved the accused land defender another year and a half of uncertainty and life under shitty bail conditions. In the G20 main conspiracy case, the pressure that the preliminary inquiry put on the Crown and the police made it possible for the defendants to strike a deal they could live with, rather than spend additional years awaiting trial. The other Commonwealth countries that have eliminated peremptory challenge, I do not believe any of them have eliminated preliminary inquiries. But again, political goal. Now, the second Supreme Court case, Antich, deals with a problem that is obvious to anyone who has seen themselves or anyone close to them charged with a crime, and that is the way the bail system works. The second you are charged with an offense in Canada, you risk immediately going to jail for months or years. And if you are lucky enough to get out while waiting for trial, it will be with strict conditions that are often hard to follow and that trap people in the system. At any given time, about 60% of everyone locked up in Canada is waiting for trial. That's in federal jails. Provincial jails is higher. There is a lot worth saying about this and how it happens, like how bail is decided by justices of the peace who have no accountability and don't need to know the laws in question, how appealing a bail decision costs thousands of dollars and takes months, how most harm caused by incarceration happens in the first few days as you lose your job, maybe your housing, and adjust to life in prison. Bill C-75 aims at encoding in the criminal code some of the principles from Antich that would in theory restrain the ability of justices of the peace to fill all the jail cells that they do. These are the latter principle and the principle of restraint. To quote Parliamentary Secretary Bill Blair, the principle of restraint's starting point is that the accused persons will be released at the earliest reasonable opportunity on the least onerous conditions appropriate in the circumstance. Now, as our anonymous author says, if anything, it's shocking that wasn't already the case. The latter principle provides a tool for meeting the principle of restraint. If the Crown is asking for a more restrictive condition, for instance, house arrest, they must demonstrate why less restrictive conditions, such as a curfew or a reside at condition, wouldn't meet the purpose of bail. And basically the purpose of bail is to ensure that the accused shows up for trial and guarantees public safety. A further element is to instruct justices of the peace and judges overseeing bails to consider whether the defendant is from a marginalized group, and specifically extends Gladue hearings for Indigenous people to the bail stage. Now, this is in recognition of the fact that Indigenous people are 4% of the total population of Canada, but make up over 25% of people in jail. Something like 1/5 minimum of all court cases are dealing with breaches of conditions. C-75, in the interest of clearing cases out of the court, invents a judicial review process as an alternative to criminal charges should a person be caught breaching a court-ordered condition. Breaches are a whole separate criminal charge that stay even if you're found innocent of the original charge. And since justices of the peace can assign whatever they want as conditions, breaching is very common. This traps people in cycles of reoffense, and nominally Bill C-75 wants to make that a bit less common by reducing criminal convictions for them. Now, there's a part 2 to this anonymously contributed criminal's guide to Bill C-75. In this part, we'll look at how Bill C-75 gives more power to prosecutors to decide how to go after people, how it changes the treatment of youth, and finally how it is reacting to social movements. Now, probably the most controversial aspect of the bill is the discretion it proposes to give the Crown about how to prosecute cases. Crimes in Canada fall into 2 categories. Indictable offenses are the more serious, and summary offenses are less serious. Certain crimes are considered hybrid and leave the Crown Attorney the discretion to decide. Under this bill, most indictable offenses that carry a maximum penalty of under 10 years will become hybrid offenses. However, it also increases the maximum sentence for a summary offense from 6 months to 2 years. This has the strange effect of meaning serious crimes could be turned into less serious ones, but that less serious crimes can now be punished more severely. Now, as I kind of alluded to before, our anonymous author here says, typically people fight harder against indictable offenses. The consequences of having one on your record are way worse, regardless of what the charge is. Poor people with indictable charges are more likely to get legal aid and be given more assistance to deal with what are considered to be more complex cases. However, this measure also means that maximum penalties for minor crimes can increase 4-fold. By having the option to seek an 18-month sentence through a summary charge rather than needing to use a more serious indictable one, the Crown can reduce the resources available to defendants and also make it more likely that they won't fight, even though the sentence and the fact are the same. For all the Conservatives claim that this measure is about dealing with delays by being soft on crime, it looks more like a way to railroad more defendants into convictions more quickly. Next part is important. As well, being able to proceed summarily makes it more likely that prosecutors and police will use certain unusual charges to target social movements. One current example, and one that the Conservative Party keeps bringing up, is unlawful assembly while masked, a charge invented in 2014 that has recently been laid for the first time, targeting anarchists in a riot in Hamilton. Until now, police and crowns have chosen to use more conventional charges against mass demonstrators, ones related to specific actions they carry out, because the constitutionality of UAWM is far from certain, criminalizing as it does participating in a demonstration without yourself committing any other crime. It seems likely that this law violates the Charter of Rights and Freedom by making it illegal to simply be present at a demonstration. Since it is a serious indictable charge that carries a possible 10-year sentence, it's very likely that those charged under it would fight it, and it is very likely that the Crown and police would have a hard time overcoming charter objections. But if they can lower the sentence and make the charge less serious by pursuing it summarily, then the risk of charter challenges becomes much less, and therefore the law is more likely to be used. Now, since this law essentially makes mass arrest legal in a way they have usually not been in Canada, making this law easier to apply is hugely dangerous. The Liberal government draws its legitimacy from being seen as responsible to progressive social movements. Bill C-75 allows them to deactivate these movements, keeping them in the realm of protest rather than having them become forces that can actually impose their will on the state. One of the biggest surges of popular anger in the last year followed the not guilty verdict being handed down to Gerald Stanley in the homicide trial of Colton Boushie. Although racism pervades every aspect of the justice system, anger here latched on to the fact that the killer was a white man and was tried by an all-white jury. The defense lawyer in the Colton Boushie case used a tool called peremptory challenges to exclude all jurors who looked Native. People were mad about that, so the Liberals are just getting rid of the challenges. The problem is that this tool has many other uses, as it is basically just a way to exclude a potential juror without relying on one of the established reasons for doing so. It could, for example, be used to exclude a white supremacist from a jury. It might mean that lawyers will have a harder time excluding specific jurors on the basis of race but it does nothing to reflect the structural inequalities in Canadian society that become visible on juries. But if the goal is to just throw a bone to the anti-racist protesters to stop the growth of a movement against the courts, then maybe it will be enough. Many measures in Bill C-75 make things tougher for people accused of sexual assault and domestic violence. This is specifically a response to the Me Too campaign, but is more generally aimed at feminist movements to end sexual violence. Notable measures include increased penalties upon conviction and reverse onus bail hearings for repeat offenders. These measures go against the direction of other aspects of C-75, such as easing bail and giving options to reduce sentences, and clearly are meant to show that the state considers there has been too much leniency for these crimes relative to others. It's hard to sell this in a legal jurisprudence sort of way when you put different focus on different parts of the criminal code, like it said in the show description. Imagine that. Law and order, try political messaging. With all the talk about children separated from their parents and jailed in the United States, it's worth mentioning the ways the Liberals intend to change how young people are locked up here in Canada. A big chunk of Bill C-75 deals with changes to the Youth Criminal Justice Act. On an average day in Canada, about 900 youth are in jail, with between 6,000 and 7,000 more in some sort of program that falls short of prison. About half of these youth are Indigenous. Kids who are locked up or placed in a facility under restrictive conditions are way more likely to continue going to jail as adults than are other youth. So how the court system treats its youngest victims has a huge impact on the future of both these individuals and their communities. The main thrust of the Bill C-75 reform is to reduce the number of youths in prison by increasing the number of restrictive programs that are technically not prison. More so even than adults, youth spend a lot of time in the justice system for breaches of court-ordered conditions, and like with adults, Bill C-75 will seek to reduce this by lessening the number of conditions and dealing with them outside of court. However, these reforms will only apply if youth are sentenced as youth. But C-75 also makes it easier for courts to sentence them as adults. At the moment, before the Crown can seek to sentence a youth as an adult, they need permission from the Attorney General, which offers some oversight and makes it harder to do. In the future, the local Crown Prosecutor's Office can make this decision, meaning more youth will not have access to the protections that the Youth Criminal Justice Act and the changes in Bill C-75 provide to them. C-75, like the conservative crime omnibus bill before it, is deliberately long and convoluted as a way of keeping us from understanding what's happening. It's hard to get an overall picture of what a bill like this is doing, and so most commentary has focused on particular aspects. But having opinions about whether eliminating preliminary inquiries or trying kids as adults or making certain offenses hybrid misses the point of the overall vision contained in a bill like this one. It's a progressive bill, but in a limited sense. It addresses specific areas of the criminal code and related legislations that have been identified as problems and changes them narrowly. The concern for efficiency in the system masks big questions, like people being pressured into pleading guilty, and certain important measures, like bail reform, are unlikely to be implemented in practice, as they remain within the arbitrary purview of justices of the peace and judges, who can really do whatever they want. There has been one wave of amendments voted on by Liberals, proposed by Conservatives, that has been approved in committee, a line-by-line review. Once it finally gets through there, it will come back to the House for report stage and third reading. So, we're at the end of 2018. It's not even out of the House yet. You know the Senate is going to shit all over this bill, which is their right. So this may not even be eligible for royal assent by the time the writ period is called next year. So the question of why didn't the separate bills work? Why did they sit around for 2 years? I have no idea. Nobody knows except the House Leader and Privy Council Clerk and whoever the hell else. We don't. What's the cure? Omnibus. Truly bizarre. Be aware of it. Keep an eye on it. Gives me just enough time to give you a little preview of my show on Monday, November 5th, 3rd Annual MMM Live on the 5. Things will be different this year. We have shed a lot of dead weight. It is most likely just going to be a couple shows. It is a Monday. Time of day, we're not sure yet. I'm coordinating with guests on 2 continents. Anybody who's familiar with our Live in the 5 marathons the first 2 years This is October 31st. Shit, we got 5 days. This is like having a month and a half for any other show. We got lots of time. Don't worry about it. We're used to this. But I can't tell you what my show will be about in a big picture sense. Well, this show page will probably be going up tomorrow if things come together. But this is my planned show description to start. Imagine you could influence regions far apart across the globe. People of different languages and cultures on the same ideological issues. From one central point of execution with those regions and cultures and masses, not knowing they are part of a larger overriding strategy. When people believe what speaks to their problems, doesn't do that at all. In fact, they're the ones being used to push an agenda that does not serve their best interests, but they think it does. Psychometrics is here to stay. It is a tool of big data. It is not limited to any global sphere. It's in commerce. It's in sales of any type. It's in politics. It's everywhere. As the things have unfolded with the SCL Group and Cambridge Analytica, Aggregate IQ, other names you may know, such as H.B. Gary, Palantir, Stratfor, this is the next level, psychometrics. Can you imagine technology and programming out there that is available to assemble 2,200 data points on you and make their own profile? And guess what? It's for sale. My show will look at psychometrics and the tools and the mission statement for activities such as this. For the hardware side of it, what's possible, what's happened, how people have been caught. Just like everything to do with the digital age, everything can be turned around on anybody else. To discuss the tools and the methods and the relatively short war history of this type of thing, one guest will be Mr. Neil Rawhauser, who is actively engaged in this realm. The other side of psychometrics is the ability to create something that seems wholly legitimate, completely real. And most of the time when this is happening, wherever the location is where something's happening, the rest of the world is convinced that what is being said is real. But yet when you go to that place to verify, you often find something completely different. To what end? What's being served? Who's being served? Who's being played? And for what? This takes a special type of investigative determination to be able to be skilled enough to see what's happening and to get proof of it and get direction with the data to where exactly things are going on, no matter what the message is, and then going there and finding out and recording it. There's a book called Alternative War, written by J.J. Patrick. J.J. Patrick at one time was in law enforcement in the United Kingdom. He couldn't deal with it and left, and was determined by certain world events to embark on a new path. He has done so, and he has not just analytical, statistical proof of some of the campaigns that are going on these days. He's been to the places where these campaigns are being centered. But, you know, as we'll find during the show, I'm sure that what appears to be the center most of the time certainly is not. It might be in St. Petersburg instead. It might be in Quantico instead. People need to understand that psychometrics is going to be around us forever now. The most valuable commodity in the world today is data. And we'll try to take a big picture look at that. So it'll be Monday, November 5th. I really don't have an official title for it yet, but it will have J.J. Patrick, author of Alternative War, and Neil Rawhauser. But once again, here's another omnibus bill from the government that said they would never have omnibus legislation. Bill C-75. In my view, it's a massive disappointment from what we were promised. But hey, sunny ways. Ain't the first, ain't going to be the last. Happy Halloween for those who partake. Thank you, everybody, for listening to The View Up Here, Bill C-75. The next show will be Monday, November 5th. I'll get the show page out as soon as I can. Thank you for listening to The View Up Here. Good night.